Good evening, everyone. Welcome. I am CA Harpreet Singh. I work for an MNC bank, and I am the moderator for this session today. And we are very delighted to welcome you all in this webinar, which is organized by CCLEA and NPO committee of ICAI. And it's a great pleasure to be moderator in the Know Your Law series. So we are running a series, and this is series 38. And it is a webinar on practice of mediation and opportunities. And it is a growing area. And we can see, of course, the participants have shown a great zeal for this. And this is being organized on 7th December today, 4 to 6 p.m. and organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. And we are starting it very shortly. The speaker, the expert is also with us. Let me tell you about the committee in a brief. So this committee is focused to encourage CAs to shape strategy and policy that unlock economic, financial, and social value while combining analytical foresight with the commercial acumen. And one of the core areas of this committee is to serve multifunctional tasks of analysis, knowledge dissemination, input to regulator on policy formations, to develop and publish technical guidance, background materials, and to create awareness for professional opportunities for us chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk on the practice on mediation opportunities in this webinar, and we believe that it is going to be very helpful to our members. Now, I would like to first introduce our speaker, guest of today's session, Mandira Mitra ji. She is a veteran. She has a great experience. First of all, if we go by the qualification, she is a BA honors from Lady Shriram College of Commerce, the eminent college. And then she did her MA from Jawaharlal Nehru University, then MPhil from again Jawaharlal Nehru University, then she did LLB from Law Faculty, Delhi University. She is accredited as a mediator and master trainer from CERD UK 2008. She is general editor of first edition of Tana's Banking Law Student Edition, which was published by LexisNexis in 2014. Since 2014, she has been in independent legal practice with associates. From 2001 to 2013, she was a partner in Agarwal Jaitley and Company, and she is specializing in commercial and business law, including banking law and arbitration. So the topic is very much relevant, and she has a vast experience in that topic. Further, she appeared before High Court of Delhi, Debt Recovery Tribunal, Consumer Forum, District Courts, and other tribunal on behalf of client. She is also teaching as a guest faculty at Indian Law Institute, New Delhi, and International Center for Alternative Dispute Resolution, New Delhi. And again, has exhaustively handled various foreign exchange transactions, export, import, etc. And she has also been a lecturer of history. So again, she is having a law experience, and she has a teaching flair also, and she has a great and vast experience. So I welcome you, ma'am, on behalf of ICI and all the members. Over to you.
Thank you, Harpreet, for this very generous introduction that you have given. One of my experiences has been also that I was with the Reserve Bank for many years, actually, as a regulator. So I was there for 13 years, and then this is in between my teaching and becoming a lawyer. So I have a varied kind of experience and background. And the topic of today First of all, let me thank also the ICAI, the institution, for giving me this opportunity to interact with your members. And this is a great opportunity for me to advocate for mediation, which I believe is really something that needs to be uh, known by professionals, known by not just advocates, but for others and also for the citizens. I hope that at the end of my lecture today and my interaction with you today, you people will become ambassadors for mediation and will be spreading the word about mediation and how, with your professional colleagues, with your acquaintances, with your family members, and talk about it as yet another way of resolving disputes. So it is as Harpreet says, it is something new. It is a growing field. So that's where we begin. So tech support, can we have the PPT, please? Next, please. We are going to talk about mediation law and the practice. So first of all, just an overview of some of the things that we'll be touching upon will be really about mediation, but I wanted to also discuss with you some related aspects, because we'll be referring to what goes on in court, what goes on in arbitration and conciliation and lok adalat, touching upon them, but mainly we will be talking about mediation. Now, how dispute resolution, how does it take place in our present scenario? You have the dispute resolution where people go to the courts or the tribunals, specialized tribunals that we have. We have the practice of arbitration, conciliation. I will be discussing these in details later on, mediation and lok adalat. Next, please. Now, you people may be aware of the term of alternative dispute resolution. So the ADR as we call them normally. So while all traditional societies had their own mechanism for dispute resolution, in my opinion, those cannot be termed as alternative dispute resolution because they were not alternative to any other form. Those were the traditional way of resolving disputes. Say in India, for example, you may have heard about that the village headman and the panchayat, the five well-known persons of the society. They would be the punches, and they had a duty, they had a responsibility, but they were the ones who would be sitting and also the finding out that when there is a dispute, the two warring parties, how do we resolve the disputes? You can give a ruling, you can give that you will do this, you will do that. So that was a traditional way of, and all traditional societies had their own ways. I don't say that they were ADR, because some people say that, oh, we have been doing panchayat and we have been doing this, so we also had mediation and arbitration before. I don't agree to that. I mean, I have a different view on that, because these things have evolved through the court system, and that is why we call it the ADR is alternate to the court. That is why when we use the term alternative to what? To the court. Therefore, I would prefer that these uh, options that I'm talking about, will be talking about, should be referred really is to as either effective or appropriate dispute resolution. In our court, as we as advocates always talk about ADR and all that, because we are actually always in the courts. And when we go out of the court to resolve it, then naturally for us, it is the alternative. But otherwise, in terms of labeling them as alternative, it has become the parlance. But I just wanted to make a distinction. Next, please. Now, what we have to understand is that how does a dispute, how do we get it from, even societal point of view, or even as legal or as professionals? A dispute is a difference of opinion resulting in differences regarding interests, rights, and liabilities of the parties. Now, these differences from time immemorial, you don't live with differences. You will try to solve it. You can try to solve a dispute by going for war against somebody. You can go and attack somebody. You can do anything, but those days are gone now. And from time immemorial, actually, dispensation of justice has been very much part of human civilization. As we've had kings, as we have had republics, as we have had other forms of government in throughout human history, you also have the concept of justice to be done. So therefore, the judicial resolution of disputes has always been there with the human civilization. And as far as we are concerned, or most any other forms of other countries also, you will have courts. What are the judicial resolution of disputes? You can go to the courts. You can go to the tribunals, which are not really courts, but a specialized kind of a tribunal for, say, you have income tax, your the ITAT and all that, which you must be familiar with. We have the civil courts, we have the criminal courts, we have other constitutional courts, and you have the ADR methods. Next, please. Next. Yeah. Now, justice, if you look at it, justice, that how is justice given by the courts? And in India, for example, we have, it is enshrined even in our constitution that you will have how justice is to be given is going to be, among other things, a very important thing is that you have to have, go by the principles of natural justice and rule of law. These are terms which we use a lot in our profession of justice giving. And what are these two things that I want to highlight, because these has play in every kind of justice system. One is the first one, where no one should be made a judge in his own cause. So I cannot be a disputing party and also be a judge of the same dispute, because I cannot be a judge in my own cause. So rule against bias. So not having a bias and thereby working on justice is the ideal situation. It is the thing that is very, very important. So if a judge is interested, a person who is, acting as a judge, as a neutral, as an arbitrator, anything you may call, cannot be having any kind of an interest in the cause in which you are involving as a judge or a neutral or an arbitrator. So therefore, uh, this first rule is very, very important, and it has its impact in mediation also, which I will be talking about. It is one of the cornerstones of mediation, that you cannot have any kind of interest in the uh, cause that you are involved in acting as a mediator. And the other is audi alteram partem, that is, hear the other side. You cannot decide, or you cannot do justice by hearing just one side. You have to hear both the sides in order to do justice or even resolve a dispute. Next, please. Now, modes of ADR in India are arbitration, you have lok adalats, you have conciliation, and you have mediation. Now, arbitration, uh, many of you may be aware of, that it is a court of your own choice, you can say. That when you go for arbitration, you have chosen an arbitrator to resolve the dispute. Both the parties have to be in unison in order to choose the arbitrator. You have already decided who is going to be your arbitrator, or how you're going to resolve if there is a dispute. It will be written in your contract, and there will be a clause in the contract, or it can be a separate one also, for going that if we have dispute amongst ourselves, either it's two or more, we will be going for arbitration. So, but it is like a court of your own choice. In a court of law, you don't have a choice as to where your petition is going to go. So you don't have a choice in that, and you don't this is not a it's not a private system. It is an open system. There will be people sitting there where your case will be heard. People will be listening to your question and answers, the arguments, everything. It is open. Sometimes it will also get reported in the newspapers if it is of something of that kind of a nature, that of importance, or there's some of interest for public. We come to know about so many cases just reading the newspaper, for example. But arbitration is private. You have you have chosen an arbitrator. The numbers of arbitrator, it can be a sole one, but it can also be more than one. And there it is a completely confidential, but there will be an adjudication also by the arbitrator. There will be, you will have a claim, then there will be a counterclaim, you will be presenting evidence, everything, all this, almost like what happens in the court. You're not governed by, the civil procedure code or similar codes, but it is something like, and the arbitrator will be giving an award by uh, reviewing the evidence and then relying on the evidence, and according to that, there will be a arbitration award. So it is really you can say it is a judge of your own, a court of your own choice in that sense. There will be adjudication like it happens in the courts. Now, Lok Adalat is something which you may have heard of. There is, I think even just now in the papers, it's coming, I think on in one of the coming Sundays, they're going to be a National Lok Adalat taking place, because this is something that has come about also because of a principle which was there in our constitution itself, and it goes back a long way in history also, that the not so well off people, the downtrodden people of our society, how do they access justice? So therefore, there's a legal services authority is there. There's a national legal services, and there's an act also on that. And they are the ones who are, given the responsibility of doing, certain types of legal service for people who are not uh, do not have the facility or do not have the ability to support their legal. They are the ones, they conduct also the Lok Adalat. And Lok Adalat is also, there are certain types of disputes. They will go there, and what they do over there is like really almost like what a conciliation is. So they act like conciliators, and it is a separate enactment in itself. It has its own place today in our judicial system. So there are nowadays a lot of the utilities, for example, they are going in purely for Lok Adalat, I mean conciliation under Lok Adalat. These are good in a way. There's a finality is reached. There is a So therefore there is some protection to the people who go and they want to resolve their disputes. Conciliation is something that is an old concept. In fact, it was there even in a very, very old enactment, the Industrial Disputes Act of 1948. You had you had conciliation officers who were there. The concept was there, but it wasn't really, taken taken to its logical, development. But conciliation as a concept is quite old also. And there also, it is the neutrals who will be who a neutral person comes, and who he or she will be acting as a conciliator. So I will not go too much into conciliation for various reasons. The conciliation, what is conciliation and how it was to be conducted, has been included in our enactment of the Arbitration and Conciliation Act of 1996. There you had a full chapter. The chapter, first time it was actually made into a statute. The practice of conciliation was in the Arbitration Act of 1996. Now I'm not going into detail, and why I will tell you I'm not getting into detail when I come to mediation. Arbitration is very, very old in India. You had the 1940 Act. Before that, you had in the colonial times, it was introduced way back that arbitration was going on, and especially for commercials. So arbitration was there. Conciliation is also old. Lok Adalat is little newer, and mediation is something which is quite new. Now, mediation got its statutory recognition in the judicial system, in our justice system. The term has been used also earlier, but nothing happened. Nothing was there absolutely about mediation. Till in 1999, there was a change in the Section 89 of the Civil Procedure Code, the CPC, which which is the procedural law for civil litigation. In that, there was a change, and in that, the uh, it said that if the courts felt that there was a possibility of resolving the disputes away from the courts, then either of these four methods could be opted for. And there came the concept of mediation was introduced, and there the courts took a lead on it, and they started setting up the mediation centers in the high courts. There's also in the Supreme Court that you had it. It's quite old, but it took some time for takeoff, but it was there, and the necessary way of how mediation is going to be done, the trainings, etc., all that was taken up by somewhat by the judiciary. The the thing is that the enactment was of a kind where it was quite well utilized in many ways, and my experience of mediation started with me getting trained as a mediator, uh, and then after that also, since I got accredited as a master trainer, so therefore I have conducted a lot of training programs. The training is a very important uh, aspect of mediation. You do not require any. You don't require a training for arbitration, except your experience, I guess, lok adalat or conciliation. But for mediation, the court itself, the Supreme Court itself, had said that you must have a certain level of practice. 15 years of being as an advocate. Only they could be eligible for the training, unless you had some other professional experience. And therefore, the training part was, so that was something new that was introduced, that you had trained people only to do mediation. And the courts started, once the disputing parties were in front of the court, the courts were at a certain stage before framing of issues, etc. The courts would see if they thought that there could be a possibility of mediation, and once the parties agreed, these cases are being referred to the mediation centers in the courts. And once, if a dispute is resolved there and there is an end to the dispute, then that is recorded in the court decree. And as an incentive, you also got a refund of the court fee that you pay. So it was a way of encouraging mediation, saying that if you resolve it through a mediation agreement, your court fee would be refunded. And if you didn't resolve it, there was no, the court is not going to be biased against you, because I'll tell you how it works. So that I'll discuss with you. And therefore, you go back to the court again. So you had the option of going, but if you don't settle, well and good, you come back to the court, and the court will then adjudicate in the normal course of things. The next slide, please. Now, generally, the cases suitable for mediation were this type of cases. You had trade and commerce and contracts, disputes among, sale, purchase of goods and other commercial, banks, financials, everybody, and also contracts. You have shareholders agreements where you had disputes. You could, you come to for that could be done through mediation. Strained relationships can be of many kinds. You have within the family, you can have strained relationships relating to, to give a very simple example would be property, and then marital disputes. So strained relationships could also be resolved through mediation. Then for need for continuation of a pre-existing relationship, which includes something like a matrimony, you had, there was a need, and or also even partnership, etc., which there is a pre-existing relationship, and it then you have get into a dispute. So is a method. This is all over. I'm talking not only about India, but where mediation flourishes and does well is where there is a need for continuation of pre-existing relationships. It can be an employer employee. Not all disputes between employer employee has to end with somebody walking out. So you can continue. So therefore, these work very well with mediation. With in litigation, what happens is, because of the way, not because of the way it is conducted, but because of the allegations that are thrown, and you discuss it threadbare, it's relationships get bad sometimes in litigation. And and also, therefore, there is a in litigation, you must understand, or even in arbitration, one person is going to win, but that is not the case in mediation. You can give and take because the way it works. Therefore, your pre-existing relationship, with whom you may be going through a temporary strained relationship because of something, but you will still be holding on to the relationship and resolving the dispute in a manner which is more peaceful and less combative, because you're not in a court situation, because the way the courts are, because the way the laws are, that it is an adversarial. We are fighting always against our adversary. We look upon the other side. We say ki other side, the opposing counsel. This is the terms we use. But in mediation, no. These terms will, when you start practicing mediation, you will not refer to the other person as the opposing side. No, we are in it together. It's a problem that you and I face together, and we are going to resolve it. So that's part of the practice, and that's part of the vocabulary. Then claims against insurance, and also I mean, that's trade and commerce also, torture. But when there's a tortious liability, you can always resolve, even MSCT cases, where you have motor accident cases, all that. They are good, suitable for mediation. Consumer disputes is another thing. If you're going to have they also do very well. It's a very well known, in all over the world, these type of disputes. These are broad categories, and there are, as the practice is evolved, there are some things which you cannot do through mediation. You can do all kinds of disputes through court and tribunals, but mediation, arbitration, all have some limitation or the other. These alternate. They are for certain types of disputes only. Next, please. Now, what is mediation? Now, this is a definition that I have taken from when I myself got trained. This is the definition that we worked upon. So it is not the definition or anything like that. It is just to explain to you what mediation is about. And there is no definition really of mediation, actually. It is the practice which distinguishes it from the other type of dispute resolution mechanism. So what is it that we talk about in mediation? It is a flexible process conducted confidentially, in which a neutral person actively assists the parties in working towards a negotiated agreement of a dispute or difference, with the parties in ultimate control of the decision to settle and the terms of the resolution. Now let's go through this a little more to see how does it distinguish itself from the others. Now, is court a flexible process? Mostly not. Court cannot become a flexible process. We have the procedural laws to see to it that it will not, because if it became a flexible process, then it wouldn't work. So therefore, that this is the time for me to do this. This is the time for me to do this. This is the stage. So at this stage, I cannot tell, no, I want to do this. No, you will have to go by whether it is permitted or not, whether the judge is going to allow it or not. So it is not flexible. And good for that. Otherwise, cannot function if we didn't have the process. So process is not in mediation. If there is one rule, as they say, if there is one rule in mediation, is that there is no rule. I will explain it to you, and you will understand what I'm trying to say, that there is no rule. And it's a process which is confidential. Now, coming to the confidentiality part of it, to juxtapose it against the court, as I had already spoken to you, that a court when you have come to the court, and your dispute will become a permanent record of the court. From later on, somebody will be writing maybe a book on a particular case. You have books like that, that people have written on one particular dispute. They have written, and they base it on court records. What was said, what were the pleadings, what were the lawyers speaking. I mean, I don't know if any one of you have read such books or not, but you can, and real life cases. So they become, your case can become if it is that kind of a, sensational case or a very, very important case, people may work on it. I have read many books like that, which are, based on just one case, starting from the district court, going up to the Privy Council. That is when we were under the British rule. I mean, two books come to my mind immediately that I've read and extremely interesting. But everything about the scholars have based their work on the one case. Then, so the confidentiality is just not there in court system at all. It is open. You are going in an open court, and that adds value also to the court system. Let me tell you, because everything is out in the open. Whatever your lordship is speaking, whatever the lawyers are speaking, everything is there, and it is all open. So it gives a sense of fairness, and it gives a sense of justice, when you go to the court also, when you go to the court. So it is a confidentiality is not a drawback in that sense. But having said that, in mediation, confidentiality, you will see, is a big, big plus. So confidentiality is a cornerstone of mediation, and in which a neutral person actively assists the parties in working towards a negotiated agreement. So the neutral party, even a judge is a neutral party, even a conciliator is a neutral party, even the arbitrator is a neutral party. So all the mechanism of dispute resolution has to be that the person who is at the center of it all, non-disputant party, has to be a neutral person. Okay, that principle holds good for all the dispute resolution. You cannot have a partisan person there. Working towards a negotiated agreement. Now we are coming, what is the end result of a mediation? Is an agreement. In court, you will have a judgment given by the court. You will have an award given by the arbitrator. So you will not have a negotiated. In conciliation, you will have an agreement. In mediation also, you will have an agreement, a negotiated agreement. A negotiation takes place between the parties. So negotiated agreement resolving with the parties in ultimate control of the decision to settle and the terms of the resolution. Now, isn't that something new? Because do the parties have anything in control when you have made your submissions, you have done your arguments? No, it is for the judge to do it. It is for the arbitrator to do it. So there is nobody is in conciliation also. It is not like mediation. In conciliation, the conciliator can give his or her own views also and say that, now look, why don't you do it like this? In mediation, no. Mediator is only a neutral who actively assists the parties. But that is the method of doing it that you will learn when you take your trainings. But The point is, it is the parties who decide what they want to resolve and how they want to resolve. And not to resolve also. You have the full freedom to come to mediation, spend some time in doing it, but then say that no, bye-bye. But can you do that in the court? No, you cannot. Once you have come with a petition and you want to, you will have to justify why you are doing. Just if you see that you will have to pay a heavy cost and the courts are not going to allow you to withdraw it at all. So therefore, this is a flexible process, as we said, and ultimately, even to decide whether to settle or not is in your hands. Next, please. Now, the types of mediation that you have in India right now are the court annexed, as I said, under Section 89. This is really the bulk of the cases that we have in India, because the courts, people go to the court because we don't know any better. We want to go to the court. You have a problem, you will get the advice, and you will be told that now, please go make your claim in the court, and you will be under Section 89. So you have lot of, and the courts, as I said, have the mediation centers, and they will be doing mediation under the court annexed. So court is the, and ultimately, if you decide and it will become a decree of the court, your mediation agreement will become part of the decree of the court. Now, the other one, which is the new thing that we are going to discuss in detail today, is going to be under the Mediation Act of 2023, which was notified as recently as 15th of September. I mean, the Gazette notification came on 15th September 2023. So it's a new act that has come about. So you may ask, what were you doing before this act? Yes, mediation was being conducted, but it was conducted in a way with no act, but there was a process which was in place, and it was certain precautions were being taken because most of them were getting court, but even private mediations were taking place, by the way. But most of them were court annexed, and now we have the Mediation Act. I will go into that also. And you also have it under the special statutes, for example, the Commercial Court Act of 2015 and the Companies Act of 2013 also, before the Mediation Act came, had the provision of going in for mediation. In Commercial Courts Act of 2015, you have that, because it is now commercial courts were carved out from the civil courts itself. The specialized courts were set up, and under the Commercial Court Act, they said that if you were under Section 12A of the 12A, and it said, and first of all, in Commercial Courts Act, they define what is going to be, what are going to be the commercial courts or commercial cases. And if you had a dispute and you were not asking for any interim protections, stays, etc., and nothing, urgency of that sort, then you had to compulsorily, you had to go in for pre-litigation mediation. This became compulsory from 2015. And this was being organized by the Legal Service Authority, who I mentioned, that the ones who do Lok Adalat. Legal service authorities have been given the responsibility to conduct these mediations. So they, in every court in Delhi, for example, if you have to file a commercial court, you will compulsorily, if you are not asking for a stay, you will have to go, and this is being followed. And Companies Act, you may be aware, it was Section 442, which was there about mediation. How the mediation, it had many provisions which said how this was going to. Now the problem was, and you had, as I said, a little bit of mention also under the Arbitration Conciliation Act. In a couple of places, the word mediation was also used without defining anything. As I said, there are no definitions as such. Now, what was happening is that and the Consumer Act also had provision for mediation. Earlier, it did not have, but they have now included it. And what has happened, what was happening in, say, we the people who are in mediation, and I mean, in the mediation sphere, also working there also, we found that, there was, in the legislations, things were getting a little distorted. I mean, nothing, I mean, there was no deliberate, but that's how the laws came about, like who would be the mediator or how the mediation process. There was certain differences coming up. Some uniformity was not there in some cases. And this discussion has been going on among the practitioners of mediation for some time. Whether to do act or not. Not every country in the world has where mediation is flourishing. They have acts. Most of them don't have, but some of them do have. And so, but in in their own wisdom, the legislature and also the judicial community, they all felt that there was a need in our country to enact a law, and therefore this act has come about. In some ways, it is probably going to give, the Section 89 never said what was going to be. It was Supreme Court who had decided the rules. There was a rules for mediation, and there it was all catering to the court annex mediation. There was no thinking about how private mediation would work, etc. We as practitioner, I remember, I in a conference, I presented a paper where I said that if I do private mediation, who is going to check me as to see whether, or any practitioner, if you are doing private mediation, whether we are doing the things that actually are required to do, and also have a certain kind of benchmark of our professional ethics. There was nothing was coming out. So everyone was saying mediation, mediation, all right, but the point is that these things needed to be put in place. And therefore, I think, hopefully, under the Mediation Act, these type of things, like who will be a mediator, what training do you require, and all these things will be, it is yet to be decided, but at least provisions have been made. And so therefore, um, this new enactment, let's see what shape it takes place. It's new, and we hope that it will be doing the service for promoting mediation in India. Next, please. Now, one more thing I wanted to add is, of course, as I said, the court annexed, and you also have the whole field of private mediation also, which needs to be encouraged. Now, why mediation? Now, what is the advantage of mediation? One of the first things that you have is cost. It is something that, since you are going in for, it is not that it is going to be that there will be no cost. Yes, there will be cost. The mediator is going to charge a fee, and the fee will be based on who the person is, or it is an institution. If it is an institutional mediation, it's not just a private one. The institution set up, and the cost is cheap, much cheaper than litigation or for arbitration. In a commercial, for a commercial entity, for an individual, the cost is one big, and cost in terms of time also. What happens in litigation, how long it takes. Even arbitrations sometimes take very, very long, and adds to the cost, because your hearings and your sittings add to the cost of arbitration and litigation. This is in places, what one reads in the books, and also by meeting mediators from other countries, they say we do it in 8 hours. Maybe we'll just do a morning to evening sitting, and we will resolve it. So you tell the people that you have. I mean, the people also know, who come for mediation, that look, I have to decide within this period. So they also want to save on costs, and so it on the whole works out to be much less expensive than litigation. Confidentiality, I have talked to you. Confidentiality is a big consideration when you don't want, uh, your dispute with your own shareholder partner, with whom you have been working for 20 years, but suddenly a dispute has come. And even if you go different ways, but at least you keep many things confidential, because suppose it is a dispute regarding intellectual property, it is regarding a design, it's regarding something which is a confidential information about the company itself and its workings, and how will this go? So whether you say stay together or you go, everything is confidential. So everybody in mediation is bound, including the mediator, is bound by confidentiality. Therefore, it is a very important consideration in many cases. And it is also very much preferred by many people who are in, for employer-employee relationship, they prefer, because they don't want, these type of disputes to come out in the open and say that, what happened, what was the dispute. So they would like to keep it, under wraps, and they want it to continue like that. And of course, in family matters also, people don't want to air all their differences in court, and write, uh, once it is put down in writing, then you can't take it back. And so therefore confidentiality is a big plus for it. Then I come to creative solution. Now creative solution is something which is a very big attractive uh, aspect of it, is that if I go to the court, I know that what prayer I will limit myself to, the prayers that I will ask for this. I cannot then tell the court that no, give me this also. No, why? The judge is not going to allow, because you have written that I want this. Now you are saying I want this also. No, sorry. That's not going to be allowed, and it should not be allowed also. Otherwise, a whole system is going to go haywire if you keep on changing. But in a creative solution, I mean not increasing, but it is increasing in the sense, suppose you are involved, for example, in XYZ dispute, and you want to then between as you go into mediation, we say that, oh, we also have this other pending issue with them, so why not resolve it now only, once for all? It happens. Don't be surprised, it happens. People come out, and sometimes they are involved in 4 or 5 litigations altogether, but they come with solving one, and along with that 4 or 5 litigations will also be liquidated. So you have, it is known, the term in mediation is known as increasing the pie. You know what a pie is? You eat a pie, you make a pie of whatever size you want to. You have come with a small size, you have come with a round pie, but ultimately the pie becomes a square pie or a hexagonal pie, because you have so many other things to decide between the two parties. And you can solve it, and they say you are expanding the pie because you are solving other things. So a creative solution can be there, which cannot be there in arbitration, and arbitration even more so, because you are absolutely bound by the contract and contractual this thing. So it's very, very limited. So creative solution is another big advantage of mediation. And the win-win part of it is, as I said earlier, that in arbitration or in a litigation, there is always a winner and there is always a lawyer. But in mediation, when you do the agreements, no, everybody has got what they wanted. It's a win-win. That is the success of mediation, is that there is no winner or loser. You are in a win-win situation, because you have resolved your disputes, and you have resolved it out of your own choice. You have decided that what I want, nothing has been imposed on me. So therefore, I go home. I mean, I may feel bad that, okay, I'm having to, this, but you are actually much more satisfied because you have taken the decision. Next, please. Now, I come down to the sections of Mediation Act. Then you will understand some of the things that they are, what all have they tried to cover in this Mediation Act of 2023. This is an act to promote and facilitate mediation, especially institutional mediation. This is very, very interesting, because institutional mediation is what we lack. today. There is court annexed is going on. Court annexed will continue to go on because people will be going there with litigation in any case. So, but institutional mediation means we also call the private mediations ad hoc. Ad hoc. So I have a little, okay, now let's mediate, and we going for ad hoc mediation. Now when we have, but we don't have good institutions in India which encourage mediation. Means they have a panel, they'll have a panel like you have arbitration, like you have ICA, for example, you have, there are others in, ICC and all that, which are, world renowned arbitration centers, but we don't have it for mediation in India. We don't have. So very good that the Mediation Act is an act to promote and facilitate mediation, especially institutional mediation. Now, these are the objectives of the act that I'm discussing: resolution of disputes, commercial or otherwise, and enforce mediated settlement agreements. So commercial, we already have started it in a big way with the act itself, that we have said that commercial disputes are now pre-litigation will be there. And enforce mediated settlement agreement is a very big development which is happened because of the act. Because earlier, when you had a mediation settlement, you did it, but it wasn't registered. There was no need to register it. And if you had to enforce it, you would have, there was no statutory backing for enforcement. Didn't have that protection. You would have to go for specific performance. Yes, you are you had an option, or you could sometimes even go back to the court and complain. But once it is it was a settlement agreement. uh, it it didn't have basically a statutory backing. That was the shortcoming of the previous situation, that if one party did not do it, then what do you do? Then provide for a body of registration of mediators. This is what I was talking about, that we did not have a professional body. Now you have, for example, you have your institute as a professor. We have our bar councils as advocates. But for mediators, it was free for all. If you wanted to do this, call yourself a mediator without training also, no one was going to ask you any questions of professional misdemeanor or anything. Honestly, this is what was happening. And so they will have a council for registration of mediators. So there will be certain norms to be followed, that who can register and how, etc. And a very important one, to encourage community mediation. This is a new concept that is being introduced. Not that it was not being done, by the way. Community mediations were taking place, but as I said, now you have a legislation to back this up, that if two communities are having a dispute, for whatever reason, it can be, and you can actually enter into mediation. So community mediation means it's not going to be, it is many number of people will be involved. It will not be 3 or 4 people involved in the dispute, but it affects something that affects a whole lot of those. So therefore, it's the community which is going to be doing, there will be a mediation. To make online mediation as acceptable and cost-effective process, and for matters connected therewith or incidental therewith. This is also a new thing. Of course, online, has come up due to the unfortunate, online mediation was there pre-COVID also, but in India, it I think became only, this whole online business became popular because of the unfortunate epidemic that we had. But to give recognition to online mediation and how to set it up, how to protect the parties, etc., all this will now come under the act, and that it's really encouraging that a very wide view has been taken while drafting this, and passing the legislation. Next, please. So the three very important that take takeaways from this new is this pre-litigation mediation, which was there, but it has been given recognition under the Act now. So, commercial acts is there, but for anything else also you can if you do pre-litigation mediation before going in for litigation, what kind of how it will be taken into consideration, all that has been enacted in the given in the. So this recognition to pre-litigation mediation for all types of cases, earlier, it was limited to commercial only. Now for all litigation, this is there. You have the choice. It is not compulsory, but it is there. And since the option is there, we only hope that people will opt for pre-litigation mediation and resolve as many as they can at the mediation stage itself, and giving recognition to online mediation and also to community mediation. Next, please. So pre-litigation mediation, the Section 5 of the Mediation Act provides that irrespective of any mediation agreement, the parties to a dispute may voluntarily and with mutual consent refer the dispute for settlement for mediation before filing any civil or commercial case of civil or commercial in nature. For commercial cases to be filed in the court, the provision of Section 12A of the Commercial Courts Act will be applicable, because it was already there in another legislation. So they are making a mention of it. In other cases, you did not have this. So therefore, now, important thing is, irrespective of any mediation agreement. Now, when you have a commercial nature, you have in shareholders agreement, for example, joint venture agreements. You must have, all of you must have done, participated in these on behalf of your clients. And you would say that they would say at the end of it, dispute resolution. First, they will say arbitration. And if arbitration doesn't exist, then, what is the court, that is what is the court, what is the jurisdiction? It will be definitely written in all the agreements, isn't it? Now you can actually put it as mediation. Why I am saying is that under the Contract Act, you have a provision in Section 28 which says that you cannot bar jurisdiction. You cannot by contract say that you will not go to the court. You cannot have an agreement that will not be a valid agreement at all. If you are going to bar somebody saying that, oh, you will not go to the court, because going to the court is very much an inherent right that every citizen has in this country. So only exception being that if you had an arbitration clause, you would have to first do arbitration. You cannot rush for anything. All of you are aware of it. You cannot rush to the court and file. If you had an arbitration, the court will say that no, please, under the 1996 Act, they will say that please go and arbitrate. Now, the special in this new act, the mediation also will be included. So you could have written mediation earlier also, which I have done for some of my clients, especially, these were all overseas clients, and they were doing work in India, and they had experience of mediation, and they were happy to include mediation. But the point was that just because you had mediation doesn't mean that you could not go to the court. So that protection, it was not there, but now you are allowed even under the Contract Act. Next one, please. So this, I think, will give a boost to mediation. In my opinion, people will consider it. Has only this dissemination of the knowledge is there, and that kind of advice is also given by, but because it's voluntary, it is not compulsory, so it is your choice. So it is not only that you had to have an agreement to mediate. Even without it, you can make up your mind and say that, okay, we have not written anything about mediation, we have not written anything about arbitration. The only choice for us is to go to the court, but let's try mediation. So you don't have a clause in your agreement, but you choose to go for mediation because you have faith in the system. You have faith in the process of mediation. Now, online mediation under Section 30. So it says that it can uh, it can be conducted on any stage of mediation under this act with the written consent of the parties. So written consent of the parties will have to be taken for doing something online. Suppose you would suppose suddenly, I mean, I'm just giving an example that you were doing some mediation, and maybe you had one sitting, and for the next sitting, one of the parties has to go, say, out of the city, or where you were, or out of the country maybe, but they want to continue with the mediation. So online, it can be conducted online, but you will need the written consent of both the parties that, okay, it will be uh, um, done through um, electronically. So any stage of mediation, you can do it, because mediation also has its stages. Then, including by the use of electronic form or computer networks, but not limited to an encrypted electronic mail service, secure chat rooms, or conferencing by video or audio mode. So these things will, take shape. This is only the law right now. We'll see what all, regulations are put in place. There's nothing as yet that what all will be there, because privacy is very, very important. In mediation, when I'm speaking, if I'm sitting in a room with the mediator and my the other the other person with whom I'm mediation, with whom I have a dispute, I know that only three of us are there in the room, or four of us are there, five of us are there, and I can speak my mind, I can say things. Because of the confidentiality that you have in mediation, I know that it cannot be used against me. It will not be used against me. And I know that nobody is present. What I am saying, if I am, suppose there is a partition family is going on. Now you, three people of the with the disputing parties are there, but there is some relative who is not part of the mediation, but you will say something, maybe it is not very flattering, maybe it's not very complimentary, but you know that because of confidentiality, I am safe to say what I am, because nothing is of that sort is going to come. So there is some sort of this thing. But if I'm doing it online, how am I to know that the other person, there is somebody not sitting in the same room? Somebody is not there. And also, the voluntariness of the parties also, in online, it has to be ensured. That is the mediation. These are tricky things, because suppose somebody is prompting you. In mediation, it is the mediator who decides who all will can sit, who takes a call on who will sit in mediation. In fact, many a times we even don't allow the advocates to come. We request them that, please, I want to have a private meeting. I want to have only the two parties, because we are negotiation where we don't want any family member to be there. We will say that, no, please, you cannot. But how am I to know that? Because we want to know from the parties what you want to decide, because that is what makes mediation successful. If anything is prompted by the third person, it will not be. It has to come from the parties who are in dispute to decide what they want to, how they want to settle. So therefore, these things, some things, but these will, I'm sure we'll overcome these issues when we are doing it, and it can be effective. Once people participate, they learn. Next, please. Next slide. Yeah. The community mediation, as I was talking to you about, Section 43 of the Mediation Act says, any dispute likely to affect peace, harmony, and tranquility among the residents of families of any area or locality may be settled through community mediation with prior mutual consent of the parties to the dispute. So this is a very, very, very laudatory, and I mean, a welcome inclusion. Community mediation is being done by practitioners in certain areas. I know of people in not in, I don't know anybody in Delhi who's doing it, but I know from some other places where they are actually doing, where community, no one person is going to take a decision on behalf of a community. It is the community which is going to decide. They have those norms, they have those practices in place, and therefore you find that everybody will participate. I have heard from practitioners in other countries who have participated in, say, um, a big, hydropower project is coming, but all that is yet to be decided because we have excluded some of these things. But I'm just giving an example, and I'm sure these will slowly, given the recognition, this will only become more and more people will be included in the mediation process. This is the idea, and it's very laudatory that it has been included. Next, please. So mediation includes a process, whether referred to by the expression mediation, pre-litigation mediation, this is definitions, online mediation, community mediation, and conciliation. Now, here I want to point out to you that we already have this Act of 1996, which includes arbitration and conciliation. So you had this whole chapter on conciliation, how conciliation is to be done. In fact, I have taken classes on conciliation in ICAI programs in the earlier sessions. And now what has happened with this new act, which is a welcome change also, is that mediation and conciliation is going to be used, the terms is going to be used interchangeably. This is what was wanted in the first place, but it didn't happen earlier with the earlier legislation. So whatever was there in the Arbitration Conciliation Act is no longer to be taken into consideration. The Mediation Act is going to override that, and the conciliation part. Even if you do conciliation, which is what I said, that in Lok Adalat they are doing conciliation, which is slightly different from mediation. So therefore, it will be called mediation again. So this is a new development where conciliation now, and Law Commission has been telling that this is to be done, that we have included it in our Section 89 and all that, but please let us drop this distinction and make it mediation and conciliation should be used interchangeably. This is how it is used in many other jurisdictions also. Or an expression of similar import whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as a mediator, who does not have the authority to impose a settlement upon the parties to the dispute. This is very, very important. The whole concept of mediation has been captured. What I have been telling you till now, that the person will be an active, a neutral, who will be actively helping the parties to come to. Never will a mediator ever say, do this or do that. No, they will help you to come to a conclusion. But there are ways of doing it. That will be part of when you do your trainings, you will understand what I'm talking about. But I don't want to speak about it now because this is not the place to do it. But you do not have the authority. So let me add, by the way, one observation that I have, having been a trainer and having trained in many groups, there are people who cannot be mediators, in my opinion, even if they get training. Why I am saying is that people, like to be in authority. It is not a deficiency. I am not criticizing anybody, but we are different people. There is a some people are participatory, some people are not, some people like to impose their views. Maybe it's a good view, maybe it is correct view, but when you are a mediator, you have to control yourself. You have to say that you just cannot do it. So therefore, everybody, only of course by training you can, but everybody cannot be an effective mediator if you do not follow certain norms that the mediator has to do. This is part of training, actually. So it is imposition of anything is just not allowed in mediation. Next slide, please. And this is definitions again. I'm introducing the definitions to you. Mediator means a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake mediation and includes a person registered as a mediator with the council. Now, the act envisages that there will be a council which is going to be, who is going to be promoting mediation, who is going to decide on many things, but these have not been notified, all these things, but there is a who all will be members of mediate and the council. So they have left it a general definition. So mediator means, so anybody can be a mediator, but there will be a requirement. Uh, if you want to, I mean, anybody can be a mediator between them if the parties agree. There is absolutely no bar in that. But in a mediation service provider, there will be certain criteria that you will be recognized as a mediator. Everybody cannot become, that's my view, that council will definitely have certain benchmarks for people who will be a mediator, and you will be registered as a mediator. So you will be governed by certain norms and certain specifications of the institution. So these are something that has been defined in the Act. Next slide, please. A mediation agreement. Now, this is different than the settlement agreement. So they have made a distinction because this was creating confusion sometimes. A mediation agreement shall be in writing by or between the parties and anyone claiming through them to submit to mediation all or certain disputes which have arisen or which may arise. So in this case, they have specifically said that a mediation agreement shall be, if there is an agreement, it has to be in writing. Now, an arbitration agreement also, has to be in writing. So therefore, they have brought this norm that the mediation agreement, if you have it in a contract, it will definitely be in writing. And it can be part of an agreement. It can be just a clause. You can do the agreement even when the dispute is there, but they should, if you want an agreement to be there, then it has to be in writing. Next, please. Now, how do I get this out of my... Okay. Now, a mediated settlement, this is a mediated settlement. When a mediated settlement agreement comes at the end of the mediation, it can break also, but if it comes, a mediated settlement agreement includes an agreement in writing between some or all of the parties resulting from mediation, settling some or all of the disputes between the such parties and authenticated by the mediator. Now, not every jurisdiction, they say that it has to be authenticated by the mediator, but our act has said that it has to be authenticated by the mediator, provided that the terms of the mediated settlement agreement may extend beyond the disputes of the referred to mediation. So you have come with XYZ issues, but you have included ABC also because these you think that are also needed to be. So it can be a broader picture, as I said, that it can be, expanding the pie, as they say. You can have that. So they are recognizing these principles of mediation practice as it has been in other jurisdictions and what the practice is all over the world. So these things have been taken in our new legislation. Next, please. Now, this is very, very, very important, this definition, and is that a mediated settlement agreement resulting from a mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them, and enforceable as per the provisions of subsection 2 of 27. So this is important, is the enforceability. Earlier, if you had a court annex mediation and you had, you did the settlement, it will go back to the judge, and they will be recording it. So they, it became part of the court decree. So there was no problem of enforceability. But a private mediation agreement enforceability was an issue because there was no statutory backing that you had to. Now they are saying that it will be enforceable under this act. So there is an act backing the enforceability of the agreement. So this is a very important thing. Next, please. So 27(2), what does it say? Subject to the provisions of Section 28, which is the challenges, the mediated settlement agreement shall be enforced in accordance with the provisions of Code of Civil Procedure in the same manner as if it were a judgment or decree passed by a court. So it's a enforceable in every way and may accordingly be relied upon by any of the parties or persons claiming through them by way of defense, set off or otherwise in any legal proceeding. So if you go with something else, it can be shown there that this this has already been decided, this has been agreed by the parties. So it can be taken as a defense also in any legal proceedings. So if the other party is taking you, dragging you to another in some other court, some other litigation and claiming otherwise, you can use this as in your defense. So this is also I think this was in my opinion, these things have come about because of the practice that has been there. People sometimes think under wrong assumption, under some kind of wrong advice also, that okay, now set this thing, but don't follow it, or you don't do it, and we'll some these things are happening. There are certain peculiarities in our society, something is happening. So I think these are taking care of to make sure and make the practice of mediation more acceptable to and make it more popular. Not popular in that sense that people should have disputes, you should not have disputes, but to make it more strong in some ways, enforceability. Next, please. Now, this is also very, very important, a challenge. Now they have, because you have come, when you are doing a mediated agreement, it is only on these grounds can you challenge it to a court of, a jurisdiction where you can go to the court. Fraud, corruption, impersonation, where the mediation was conducted, in dispute of matters not fit for mediation under Section 6. So there are certain matters which I'll discuss with you briefly, that certain types of disputes are being specifically excluded also by this, and further can be added also. So what they're saying, that if somebody unknowingly or by mistake or whatever has done a mediation, saying that okay, settle this by mediation, but this was a dispute which could not have been under mediation, you would have to go to the court, then that can be challenged under this. And fraud, corruption, so very limited, so which is good. Means people should know this and then go in for mediation, that it cannot be some sort of a stopgap thing, that we'll do it and then we'll not follow, and then we'll go back on it and all that. And challenging is also that, to say that I did not say this, I did not do that, all that is not going to work also. So this is encapsulated, and hope and I think it should be a deterrent for uh, frivolous challenges. Next, please. So then I have now come to the conclusion of my presentation, actually, about the mediation practice. Why I'm bringing this also to you is that I feel that from now on, the scope of mediation practice is being widened. Why I say it, that all this while it was really, what was happening in India was the court annexed. So the mediation practice was really being, was limited to advocates, because it was court, and then the advocates were the ones who were getting trained as mediators. Though I know people who are not advocates who have done mediation training, but it wasn't that easy, or it wasn't very common. But now the act is silent on who the mediation. Of course, those regulations have to come. They may have some that how much, say a chartered accountant like all of you, how many years of practice at the most they'll say that, or what qualifications you should have and all that at the most those type of things can be there. So I feel that the scope of mediation is being widened with this enactment. It is going out of the court system. It is becoming for all people to participate in it. And people who are interested to do mediation can come You have community mediation who are, maybe community leaders. In fact, I saw a very nice news report where it was a clip on, someone had sent it, where, in Indore, for example, they're having mediation. There's a large Sindhi population over there, and the Sindhi community, they have decided that they are going to have mediation over there, and they will do it among themselves, whatever disputes are there, and they have appointed certain people who are well liked, well respected in their community to be the mediators. I don't know if they are trained or not. That is, I am not aware of. I only saw it, and it seemed like that things were happening there. So, you have the chambers of commerce, for example. You have chambers. Where, many of their disputes don't reach the court. They do it. Now, if it is done through mediation, you will have some protection under the act, and who will do it, and things. And then not necessarily that it will be only advocates who will be the mediators. You will have I have trained, in my training experience, there have been people who are not advocates, and they have, because they wanted to do mediation, a couple of them actually went abroad also and were practicing, and they wanted to do mediation because these qualifications of an advocate was not required. The proposed council will give direction and shape to the practice of mediation. This is what we, as people who were doing trainings, doing mediations, we were wanting this to happen. That there should be a regulatory body, somebody who will listen and will has set some examples, set some standards. So this is very, very welcome. Training and continuous updating of skills should form a very integral part of this practice, and we hope that the council is going to set that, because continuous training is very important. Like where I got my training, I mean, CEDR, now, because of technology, I can participate in, the seminars and all that they are conducting, and I keep in touch with newer developments that's going on. So continuous updating of skills and training is going to be an integral part, and accreditation and standard of practice will evolve and develop. This is also something extremely welcome, which has been envisaged in the act. A few things I wanted to tell you, that which are the type of cases which they say is that which are not fit. Section, the first schedule, it's under section 6. The first schedule is there. So disputes involving prosecution for criminal offenses you cannot do mediation. Now, one thing is that complaints or proceedings initiated before any statutory authority or body in relation to registration, discipline, misconduct of any practitioner or other registered professionals such as a legal practitioner, medical practitioner, dentist, architect, chartered accountant, or in relation to any other profession or whatever description which is regulated under any law for the time being in force. So that is not going to be mediated. That is out of the scope of mediation. Then you have, for example, any proceedings in relation to any subject matter falling within any enactment over which the tribunal constituted under the National Green Tribunal Act of 2010 has jurisdiction. So things on environment, on climate change, all that will not be mediated, so that they don't want it to be mediated. Then any dispute relating to levy, collection, penalties, or offenses in relation to any direct or indirect tax or refunds enacted by any state legislature or parliament cannot be mediated. So these are some of there. Then Electricity Act, appellate tribunal for electricity cannot be done. For petroleum and natural gas, which is there in the tribunals, that cannot be mediated. As of now, they have said all this is there, and any other subject that which may be notified. So this schedule can undergo changes, and they will be they can add to this list also. The list I have read out now, that's not going to be so That's where I conclude my presentation to you. And before we break, do we need a break or should we continue with the questions? You are muted, Harpreet.
Sorry. Yes. Sorry, I was on mute. Thank you so much for a wonderful presentation, ma'am. I think we can take a few questions of the members.
Okay,
Um, so there are a lot of questions that we have. So I'll be reading them one by one.
please.
There's a question: if a mediated settlement is enforceable, then under what circumstances will it be appealable in court? Like Future Group did not agree to arbitration award of International Tribunal in favor of Amazon
Mm.
and challenged it in Supreme Court. So basically two
Arbitration
parts of
is
the question.
okay. Arbitration is under the act itself, you have the right to appeal, you know. So there is no appeal actually allowed in mediation at all. So if it, you can challenge it only on those four provisions that I talked about, that under those, so mediated settlement has no provision for appeal. Even Lok Adalat actually, conciliation, when you do conciliation, which will now be no like a mediation, it is not appealable at all. It is a final thing. So this is a, it is not an appealable as such. You can challenge it by saying that there was a fraud, there was impersonation, etc., etc., or the subject matter was not to be mediated. So therefore, arbitration and mediation act is totally different. It doesn't even envisage mediation at all. But so you can go only if these things are present. You find that there has been a fraud, there has been an impersonation, then you can actually go and challenge. You can challenge it, but you cannot. There is no question of appeal.
Hmm.
Is that
Okay,
is that
sure.
clear?
Yes, and then arbitration, of course, it's not, of course, it is a bit different to what our topic was. So, okay. And then please elaborate the qualifications required for mediator and mediation service provider. Can a chartered accountant be mediator and register himself with mediation council?
Mediation council is yet to come out. I mean, it's yet to be, we do not know anything as to what they are going to say. Like, for example, what the Supreme Court has said about mediator qualifications, that you have to do a 40-hour training program. We do it over a couple of days. That come out is there, where we teach about the process, where there is a theoretical as well as practical, and you do it over a period of time. So 40 hours is required. 15 years of train as an advocate. You should be an advocate. These are the things that the Supreme Court has specified. But what the council is going to say, I'm afraid I can't say. And yes, of course, as a chartered accountant, you anybody can do it, but provided they will have to set those norms, that what will be the training program and how many hours that you will be required, and who will provide, and how you will do it, where will you do it from, which will be recognized, etc., will be the work of the council. So most welcome. Look forward to CA friends to become mediators.
Sure, ma'am. So the 15 years of that requirement of being an advocate might be changed by the mediation council.
It
That's
can be. It can be. I mean,
yeah,
the Supreme, whether that will be applicable only for advocates, that is already applicable. So we find there are very young people who are interested in our profession, who are interested, but unfortunately, they don't qualify under that. So all that is. Let's see what the council does.
sure, ma'am. Then the next question is if mediation council is there in agreement, both the parties are bound to first discuss this possibility or with this option before going to the court, or they can
That change in the contract act is going to come, and they are going to put that mediation, whether mediation becomes compulsory. No, it is, as of now, it is not compulsory. Whereas in Arbitration Act, actually, it is written that you cannot go to the court. So let's see how that law, that this particular provision of the Contract Act, which will be there, it is not saying that you cannot go. That is thing. But if you have written, you are likely to go for mediation. That is the assumption. If you write mediation now, as I said, most people don't, they are not writing mediation that you want to go. But once you say, if you both parties do it, then but like arbitration, as you say, you are prevented from going to the directly to the court. That is not clear in this at all. But you can write it in your
Sure.
contract. So you can
Okay.
bar.
But if
Yes,
we write, then we are bound to go, and
bound to.
we, after mediation is done, can't really challenge in court.
Yeah, there is a
Bound
finality
to
that
go or not, finality.
you are you
I
are
got it.
you are
Bound to
you are
go is
bound to
not
go
a
because, yeah, you are bound to go because you have agreed to go. Before going to the court, you are bound to go, yes. But you will, it will play out in the court. When you go to the court, then what the court will, how it, that is, let's see what the courts say about it. Okay.
sure, sure. Uh, Next question is it necessary for commercial cases to file in courts before mediation approaches?
No, but under the Commercial Courts Act, 12A says this. I'll just read it out, that under what is commercial court, you will have to see. And the 12A is pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by central government. This is part of 12. This is what 12A says. So the central government may by notification authorize the authorities constituted under that is not important. The 12A1, if you read, it says a suit which does not. So if you go and file in the court, they will not accept it in the registry itself if you are not asking for it. Today, as of today, since 2000, I mean, when this amendment was there. All right. This chapter 3A, the pre-institution mediation settlement of the Commercial Courts Act. Now, if you must fall also under the definition of the commercial, which is a very wide definition. So what is commercial has been also defined in the Act itself, Commercial Courts Act.
Sure. And there's a follow-up question. If there is no consensus, for example, then mediation process can be a way to create delay in commercial dispute. Is it true?
Uh, Create delay for what reason? Because your limitation is not going to be affected if you go in for mediation. This will be excluded. So what benefit do you get? You may get some time to do something mediation. People think people think on these lines. Yes, it's a very valid and a real question, I will say. Yes, they think like that. But as if mediation practice, grows and people participate once and they experience it, they will realize that it is not only delaying tactics. You actually will benefit by resolving your disputes.
Sure, sure, ma'am. Another question is, can you please suggest a book where we can read about arbitration dispute, for example, between Amazon and Future Group, or where different case studies are there related to this?
In arbitration,
In arbitration and mediation both. Yeah.
the mediation books that are there are really on the practice of it. There, it's not about case laws. Actually, I mean, they won't, because in mediation, because by the way, because of confidentiality, even if I was, say, in my training program, going to give you an example, I am never going to take the person's name. I'm going to change things. It's because of confidentiality. So you will never come to know what happened because we are bound by confidentiality. The mediator is as much bound as anybody else, more so. And the protection against this is that you cannot call the mediator for giving evidence that mediation में ये हुआ था वो हुआ था इसने ये बोला so and so said this so and so said that. It is not going to be, nobody can, no, it cannot have any evidentiary value at all. So confidentiality is there. So the mediated cases are not going to be available to you for discussion except in books. But then the case, it's all concealed. Whereas arbitration, you can read any of the books on arbitration. You can get them. That is there. All book on the act itself. You read the books on act. I don't know. I mean, what we consult is the Arbitration Act books itself, where we come to know about the case laws and what were the decisions. And in Supreme Court, the SEC online, you can check on those by giving the names. If you subscribe to SEC online, your institution does it, then you can go to a library and read it. Such type of cases, the well-known case laws, that's what we do all the time. I don't know if I have answered it to the satisfaction of the.
No, no, you answered it elaborately, and
All
I
right.
mean, of course, it was quite
Okay.
obvious. And one more question is, can party opt for mediation after the arbitration proceedings?
Yes, yes, very much, very much, very much. This is very common. There's, now it's ARB Med. They call it ARB Med. They call it Med ARB. It's a combination. So while you're doing arbitration, you suddenly realize that, arbitration is going to give me limited award, a limited benefit. So you can convert it into a mediation and make it a um, then you start negotiating. No, you will be getting into a negotiated agreement. In arbitration hearings, you are being heard as different parties, and the arbitrator is weighing everything, and you are doing written submissions, evidence, everything you are doing, cross exam, everything you're doing. But then you say, no, this is not. I think there is a zone. There is a zone of settlement is there in the minds of the two parties, so they can change that arbitration into mediation. That is provided even in the act itself, mediation in the arbitration also, and you can change it anytime. But you should sign a mediation agreement and say that now we are going to act as now we are going to go for mediation. Now in this case, the one of the issues that used to come up, that can the arbitrator become a mediator? But there is no clarity on that, in the sense there is no uh, it is only that once you've been an arbitrator, should you also become a mediator? There are different views on it. Some people say no, you should not, but let's see, we don't have any norms right now. So arbitrators, sometimes they do convert, and if the parties have faith in the mediator, anything is possible.
Sure, ma'am, sure. These were the questions that we had. Mayank, can we close, or we have to wait for some chairman or someone else? We are
Yes, we can wind up now.
okay. Great. So,
Thank you,
ma'am,
Mandira ma'am. Thank you,
I'll
Harpreet Singh sir.
yes, thank you. I'll just have the official vote of thanks here.
Yeah, sure.
So, sure. Thank you so much. So, Mandira ma'am, it was a great, wonderful session. Throughout the session, I was just jotting down the points, as I myself is a student of law, and
Okay.
yeah. So I was able to, link it to what I have studied, and the practicalities that you mentioned, and the references that you drew from outside the country, because there we are having, I think, more kind of exposure into this, and we are progressing slowly, but yeah, steadily in this direction. So yes, it was a fantastic session for personally myself and for all the members. So on behalf of the committee, ICAI, all the members and myself, I thank you so much.
Thank you, ICAI, for giving me this opportunity. I hope that all of you will be ambassadors of mediation in your professional and personal life too. Do talk about it with people that this option is available. So thank you very much, Mayank. Thank you.
Thank you, ma'am.